It's already a great event for me because I have already learned a lot, and I will add a few ideas that came to my mind when I listened to the previous speakers, which you cannot find on the slide. Yes, we are turning back to Europe. That's correct. And of course, one could now ask the question, since we all know about the competition law arguments on the table from the US, how do we phrase this under EU law? This is not the major question I will ask. I'm interested in a kind of a different question, namely, since we don't have something like Hatch-Waxman, why do we still have a problem? What are the reasons for the problem? Because, of course, in the United States, one could also argue, why do we care so much about antitrust law? Maybe we should reform Hatch-Waxman, and then we have solved the problem. But if we had a problem also in Europe without Hatch-Waxman, this might mean that the US would also have a problem if they reformed that law. So that's, I think, from a comparative perspective, quite exciting, because this also tells us that the US Americans should be interested in the European situation. The European situation is incredibly complex and quite different. First, it's incredibly complex because if you take into account the more overarching regulatory system, you also get international law, number one. We have some features of the whole landscape which are European law, namely EU competition law, and we also have mostly, especially in the pharmaceutical industry, centralized patent grant, namely from the European Patent Office. But then everything else, or practically everything else, there's still an exception, which is union law, is national law. In the United States, those settlements are entered into during court proceedings. In the European Union, we have different procedural laws. We have two laws in the European Union, two national laws, or two member states, that have bifurcation. I don't know whether you know what bifurcation means. In Germany and Austria, you can't rely on the invalidity of the patent if you are sued for patent infringement. You have to go to a different court and sue for getting an annulment of the patent. So the two procedures are completely separate. This is not the case in the United States. So the overall procedural context of settling cases before courts is certainly very, very different in Germany, which after all is the most important country in Europe where patent litigation takes place. And then, in addition, there are national concepts of court settlements. In some jurisdictions, maybe it's a simple agreement between the party. As far as I understand, in the UK, courts play a major role. You may wonder whether this is a court decision or simply an agreement among the parties. What's the role of the judge? Can the judge say, no, I don't accept that settlement because there is an antitrust violation? In Germany, we are a little bit in between, because if you settle a case before the court, you can rely on the settlement just like on a judgment. But the judge is not supposed to question the validity, or usually not supposed to question the validity of the settlement. Actually, we are now discussing whether judges have to take competition law into account when they actually take down the settlement. So it's extremely complex. Then Hatch-Waxman. Hatch-Waxman actually has three parts, and one part is also the one we find in Europe. In Europe, we also have something like ANDA. Generic companies can go to the marketing authorization body, to the agency, and apply for a kind of an abbreviated drug authorization, relying on bioequivalence. So this is much cheaper, as explained. But we don't have the patent linkage, so bringing such an application as a matter of law is not considered a patent infringement, and we don't have the very specific exclusivity protection. What does this mean? Of course, this means if you settle the case with one generic company, maybe immediately another one would come in. And maybe you can't pay them off all. So this should reduce enormously incentives for originator companies to settle cases. But still we have them in Europe. So that's kind of a puzzle. If you think more precisely about the situation, you immediately see that the situation has to be very different. Think about a generic company. A generic company knows about a drug or a substance which is very powerful, a very good drug, and you want to produce a generic version of it and bring it to the market. When you bring it to the market, right away you immediately go, you know about the drug, you go to the administration, you get the allowance. Will you sell it immediately? Well, you take enormous risks because you will be sued for patent infringement. There's an option. You may to the court and get an annulment, but then everybody else will benefit from it. You pay the costs for the proceedings, and all generic companies will have the advantage. So you take enormous risks and maybe you won't do it. You won't enter the market. The risk is too high. What happens is you wait until the end of the patent term. And this is what came to me today, I have to admit. If you look at the European cases, I would call them late cases. In the US we have early cases because Hatch-Waxman creates an enormous incentive to challenge such a powerful drug immediately and the patent immediately, and this is actually the purpose of Hatch-Waxman. But we have late cases, and the cases we see here in Europe are more kind of an issue that is termed life cycle management cases. So it's very much at the end of the patent term, maybe even later. You will see this when I come back to the cases. Since time is running, I will get immediately to the development of the debate in the European Union. You have already heard quite a bit about it. The sector inquiry was extremely important for bringing up the topic. I counted 4 cases. The 4th case, the fentanyl case, which was also opened, the last case in 2011, is a very strange case, and maybe it does not really fall into this box. But nevertheless, I think it's interesting. And then I will open up the picture even a bit more and have a look at the technology transfer block exemption regulation, which is under review now, because the Commission is also proposing interesting things with regard to licensing when so-called non-challenge clauses are included, which actually come up if we have a settlement that includes a licensing contract and a non-challenge clause. So the two phenomena, a court settlement and a licensing contract with a non-challenge clause, are practically substitutes. It's even very difficult to distinguish the two. And then I would also like to have a look at the UK situation, because quite interesting things are going on in the UK. A few words on the sector inquiry. Sabina already told you something about it, but here I come back to my observation that we have late cases. According to the report on the sector inquiry, the Commission counted 700 cases of litigations, and now look at the numbers. We had 149 final decisions, and in 62% of the cases that were litigated to the end, the patent owner lost. So in the majority of the cases, the patent was considered to be invalid. I will come back to this point too, because it tells us something about patent strength and so on. And there were 207 settlements. If you add the two numbers, you can see there's a large difference. Where's the rest? Answer: those were ongoing cases. So there's an enormous amount of cases that are currently litigated or were litigated in 2009. This may also explain that in the 3rd monitoring report, numbers suddenly went up again, because those cases were already counted in the sector inquiry report as pending. Why do we have so many pending cases? The reason might be, that's my assumption, the reason might be that many of the very powerful pharmaceutical patents are getting to the end of their life cycle. And now the generics companies try to enter the market. And now we have litigation going on concerning the validity and, of the patents and so on. So, and the problem is, that's an overarching problem in the pharmaceutical industry. It has become extremely difficult for pharmaceutical companies to find new compounds, to get new patents for completely new drugs based on chemical compounds. Biopharmaceuticals is a different story, but in the field of classical pharmacology, this is a major problem. So the pharmaceutical companies are afraid of losing their strong market power, and they will lose it to the generics companies. That's the economic problem behind this. And so this also explains why in the third monitoring report, the Commission says, well, by number, the cases that are problematic are going up. Only the percentage is going down, because obviously the firms understood there might be a problem if we include a value transfer in our settlement. Just a word on the sector inquiry. If you look in the sector inquiry report, which is extremely long, the question, of course, is, does the Commission say anything about the legal assessment? The answer is yes and no. The Commission expresses, obviously, a very strong belief in the fact that those cases are highly problematic. They may violate competition law, but that's it. So these might be potential violations of competition law, but the individual cases still need to be assessed. That's very important. The sector inquiry is not supposed to make individual decisions. Very clear in this regard. But we have to be careful, because also in the second monitoring report, the Commissioner Almunia said, wonderful, we won, because now the number goes down of potentially anti-competitive agreements. Well, should be happy about fewer cases of potentially anti-competitive agreements? I don't know. If they are not anti-competitive, then we might have a problem. But you will see I support the Commission, don't be afraid. On the Lundbeck case, I'm very grateful to Sabina, because she already explained it much better than I could do, because I have to rely on very scarce information. Unfortunately, the Lundbeck decision has not been published yet. I'm very grateful, because she actually answered a question I had, namely the role of the process patents. And especially this case demonstrates my argument that these are late cases. The product patent had already expired, and there were only process patents on which Lundbeck could rely. The process patent is used for the production of the patent of the drug. So which process do I have to use to actually get the drug? It's not the drug itself, which means if I have a different process for producing the same drug, I can produce the drug, because the drug as such is no longer protected by the patent, right? So this proves a bit my case that this is a late case. So the patent had expired, and now there's a dispute on whether there's an infringement of the process patent. So this already makes this a rather, I would say, weak patent case, right? Quite interestingly, we should also mention this, there were additional forms of anti-competitive conduct. What Lundbeck also did, and it's quite amazing, they bought large volumes of the generic drug. So if you are convinced that the drug violates your process patents, why do you buy them? That's very strange, I find. But it's quite a different form.
Maybe you don't know.
Maybe you don't know, sure. Sure, and maybe it's cheaper to buy than to litigate, I don't know, maybe. Quite right, I'm not arguing against it. Lundbeck has now brought its appeal to the General Court, which is also interesting. And what I found on the internet is that Lundbeck is basically relying on the fact that the process patents are valid and that they are infringed upon. So they are trying to make this case a purely patent law case. And we will see how this turns out. The Servier case maybe is even more interesting. Also a very complex case in addition to what Sabina said. Also, this is a late case. The first patent had expired, and now Servier is relying on a so-called second generation patent. And everybody who knows about the discussion on pharmaceutical patents and their validity knows that those patents are even more often invalid. So maybe more problematic cases. And indeed, a UK court actually held that the patent was invalid. But previously, the opposition division of the European Patent Office upheld the patent. So the question was, obviously maybe this seems to be a very weak patent or an invalid patent, but at the time of the settlement, the parties maybe did not know about this. It's interesting to see that the UK government brought a private claim before English courts and sued for damages. Why? The UK government is paying for the drugs. They are financing the national health system, the NHS, sorry. So, and they brought a claim for 220 million pounds, quite a large sum. And there, the government relies on the argument that actually Servier had known that the patent at the time of the application that they did not have a right to get the patent, that the state of the art would actually not support the patent or any other reason, I don't know. But that's the argument of the UK government. So actually here this would be termed in the US debate a fraud case before the patent office, which would be handled very, very different also in the United States. So a much clearer case maybe if the arguments are correct. The Cevalon case seems to be a standard case. We don't know too much about it. What I found most interesting is a completely different story, a side story about the case. The statement of objections by the Commission was made in 2011. Shortly after this, Never tried to buy Cevalon. So the generics company came and wanted to purchase the originator company with the patent. And they had, of course, to notify the merger to the Commission. What did the Commission say? Yes, you're allowed to merge, but under a condition, namely the condition that Cevalon sells its own generic version. Another feature of patent law. It happens quite often that originator companies, when they get at the end of, especially when they get at the end of the life cycle of the patent, start to produce their own generic version. So they sell the same product, one under the original brand and then under such a version. So what under a generic version. So by doing this, the Commission tried to maintain the competitive situation, to make sure that now the two parties would not simply disappear by merging. They want to maintain competition by generic companies. What is also interesting is that the generic company is not always the poor guy on the block. Neva, a generic company from Israel, is an extremely rich and powerful company. And originator companies can be smaller. And we have much more diversification nowadays in the industry. So to distinguish between originator companies on the one hand side and generic companies on the other hand side, nowadays is no longer so clear, right? The fentanyl case is a very clear case. We could also call it Johnson and Johnson versus Novartis. Fentanyl is the official name under which you find it on the website of the Commission. Why is this a clear case? Well, the patent has already expired. It had expired in 2005, and Johnson & Johnson still wanted to sell the product at high prices in the Netherlands and got into a deal with Novartis, and Novartis has a generic subsidiary, namely Sandoz, and they called the agreement a co-promotion agreement, promotion of the economic interests of both parties maybe, which actually created an obligation of Sandoz to stay out of the market with monthly payments. But you can see, patent validity is not an issue. The patent had already expired. It's a clear case. It's a clear case on life cycle management. But of course, it delays generics competition. I would also mention that the UK Office of Fair Trading has also started a case concerning GlaxoSmithKline, the firm that we will hear about from Korea. I don't know whether it's the same drug. I didn't check. Maybe I'm wrong. I don't have much information. It's a most recent case, but you can see in the UK it's a particular issue, also because it's the government budget that is directly affected, and we know about the budgetary problems in the UK. If we compare the cases, we could make a list of the clearer cases and the less clear cases. Fentanyl, to my opinion, that's clear. Also under US law, this would violate competition law. You are not allowed to extend your market dominance beyond the expiry of the patent term. Servier, here we already know that the patent is invalid, and maybe there was bad faith on the part of Servier. At least it is argued that this was the case. In Lundbeck, I'm now wondering whether I should put it first prior to Servier, after what I have heard from Sabina. Very similar case, we have a reverse payment. It's a weak patent because it's a process patent, but as I heard now, the Commission is of the opinion there was not even a violation of the patent. Then it would really, maybe would have to be put first, because then this would make the case much clearer. But there might be disputes about whether there is an infringement or not. This is also a very difficult question, just like whether a patent is valid or not. Whereas Cephalon and the GlaxoSmithKline cases, we don't know much about it. We don't know anything about invalidity. And so this is a very, very open case. And whether we require bad faith or whether we require patent strength might matter a lot for those two cases. What is also quite interesting is that in all those cases, the patents were extremely important, the products were extremely important. Usually the most important drug for the specific originator company, and they had market dominance for those drugs. That's a general feature, and they want to extend this market dominance mostly beyond the term of the patent protection. We can also see that there's a large variety of different value transfers. It's not just about payments, it's about licenses, distribution agreements. So this also advocates more thorough analysis of the cases. And there were additional forms of abuse, especially in the Servier case, abuse of patent filing procedures. This comes very close to AstraZeneca, because in the AstraZeneca case, which had been decided by the Court of Justice, there was also abuse of the procedures before the marketing authorization agencies. And this might be a precedent also for this case. And I would advocate to distinguish between the different forms of conduct, right? So even if we think reverse payments has to be dealt with more cautiously than in the United States, we might still have a case with regard to other forms of conduct. On the economic incentives, why do those cases arise? I already mentioned that cases in Europe seem to be late cases. There might be other reasons concerning procedures why we still have cases. But what we can see is that despite the lack of marketing exclusivity, like under Hatch-Waxman, we have those cases. in some cases, what we can see is that the originator companies paid to several generic companies, 4, 5, 6, 7. Like in the Xavier case, I can't even remember, 6 or 7 companies were paid by Xavier. So there seems to be an incentive to invest in keeping generics of different companies outside of the market. There are other features that may limit access of generics to the market than the exclusivity protection we find in the United States. First of all, what is very important is that the first entrant, the first generic product that enters the market usually gains a lot of market power. The first product is sold also in the United States after the 180 days exclusivity period at a much higher price than the second and third comer. Why? Doctors know the brand, they trust the brand, they already got used to the brand, and they will continue to prescribe this brand because they know this is a generic and it's sold at a lower price, but they will not take so much into account other generics that may enter the market much later. So the time of the market entry is very important. And as I mentioned before, we also have generic versions of the originator companies. So if you have a situation in which the originator generic version was number 2, and you want to get rid of number 1, then this is a wonderful situation, also in Europe. I have not seen anything that analyzed those cases from this perspective. You don't care about number 3, right? So another feature is that it also takes time to sell generics in Europe. In many countries, there are regulations on whether certain drugs can only be sold with a prescription by a doctor or not. This takes time. Making decisions on the appropriate price regulation, takes time. So this delays the entry of additional generics quite considerably.
Just click on that.
Okay.
If you click on that further away.
Okay. Oh no, this is correct. Sorry. There are also substitutes or other mechanisms that actually promote litigation. For example, I have a doctorate student who also works on the topic, and he found out that there is a patent linkage in Hungary, maybe in contravention to European drug law. In Austria, courts have decided when you file for a marketing authorization, this can also be considered enough ground for bringing an action for injunctive relief, because it is assumed if you apply for the marketing authorization, you will also want to enter the market. So this was considered to be sufficient, and there's debate in Italy, as far as I know, whether this should also be the law in Italy. Another aspect which I find extremely important is the argument of raising the bar. The term raising the bar comes from discussion within the European Patent Office. And the argument is, maybe we should do something about patent quality. The patents that are granted by the patent offices are not reliable. Too many of them are invalid. If we check and examine those patents much more carefully, then we will not have this problem anymore. Answer, is this correct or not? Answer, yes and no. We have higher patent quality, certainly in Europe, than in the United States. But we will never have high quality. Why? When do pharmaceutical companies apply for pharmaceutical patents? Very early. Once they have a compound and they get the idea, maybe we can sue this for a marketable drug, they will apply for the patent. And because they want to protect their investment in developing the drug. But at this time, you certainly don't know that this drug will make it to the market. And it's only a very, very few patents actually make it to the market. You don't know whether the drug will be safe, what effects it will have, whether it will be effective. And certainly you don't know whether this will be a powerful drug with which you will have market dominance. So if you compare those numbers, you can see that at the end, only a very few invalid patents are economically so important that they are worth to be litigated. And nobody is interested in the rest, right? So the question is whether we want to invest so much money in higher quality of the patents if, after all, it's much more reasonable to take litigation into account and then solve the problem at this later stage of litigation. On the European law, Sabina also already said something. I would not go far beyond this, and therefore also to the assessment. My opinion is, in general, it's fine. What I like also about the US approach is that they argue against the need to check the validity of the patent. In the US, the question was whether the courts need to check the validity of the patent. In Europe, we have to ask ourselves whether the European Commission has to check the validity of the patent. And of course, we don't want this to happen. We don't think that the with all due respect, that the competition Directorate General does not want it, and they don't have scientists to do this. So this would be a good idea that we don't enter into this. And I think in general the US approach is correct in this regard. I would have additional arguments, but maybe I should not tell you this. What I find most important, oops, it's already. So what I find most important, last slide please, because I added something here, is the one that is at the very bottom. We also have to take into account procedural law, because procedural law is extremely important concerning the incentives of whether cases on patent validity actually reach the courts and in what kind of procedural circumstances settlements take place. This can be done by patent law. We want to promote such cases, but then at the other hand, we also need competition law, because only competition law can make sure that collusion does not take place, which is the second issue that necessarily comes up in this context. Thank you very much.